left off in class earlier today, hopefully with jurisdiction, and we start with exclusive. Jurisdiction means who gets to hear the case, who has the right to hear it. So exclusive jurisdiction means that only a federal court can hear this case. For example, when Charles Lindbergh's baby was kidnapped, law was changed in the United States because we realized that when people kidnap other people, many times they don't stay in one place. They will try to be on the move and on the run and could easily cross state lines. So today, kidnapping is a federal crime. If you are accused of kidnapping another person, you will be put on trial in a federal court, even if the kidnapping occurred within one state. So exclusive means only the federal courts will hear the case. The next is called concurrent. And concurrent means that you could be put on trial in either a federal or a state court. There were two people who were the DC snipers, John Muhammad and John Malvo, I think was the other guy. And they went across several states shooting and killing people at random. When they were eventually caught, they were put on trial for almost all of their crimes in a federal court. See, most of the time what happens is that the states are more than happy to let the feds run the trial because you could have multiple charges from multiple states all addressed at one time in one trial with one jury. And so the federal government can take those individuals, put them on trial, and if they are guilty, get a conviction. In this case, all of the states except, I believe, Maryland, allowed the federal government to try and convict those two individuals. Maryland, however, said, you know what? We don't want our charges to be part of this case. And they decided, after the federal government had convicted them, of bringing them to Maryland to face trial. The state has the right to do that. The reason they wanted to do this is Maryland had the death penalty, and Maryland felt that their crimes warranted execution. So they wanted to put them on trial and potentially execute them, whereas the federal government would not. Original jurisdiction just means you are the first court to try the case. So most of the time is in a federal system, you start at what's called a district court, which is a trial court, and they would be the court with original jurisdiction. Now, if you go and have a trial in a district court, and after the trial believe that some aspect of the trial was unfair, then you can file an appeal to an appellate court. The appellate courts, and we'll see maps of them in a little bit, but the appellate courts are not concerned with guilt or innocence. A district court is. They want to determine whether or not you committed the crime. The appellate courts are simply interested in whether or not any constitutional rights were violated. They really don't care whether you committed the crime. That's irrelevant. They want to make sure that due process was followed and that the Constitution was obeyed. The ultimate appellate court in the United States is the Supreme Court, but there is a step between them. So, continuing, we're looking at jurisdiction of the federal courts in particular, and you will see federal courts can try a case if it involves the Constitution, a federal law, or a treaty. If it occurs on the high seas or matters on land but relating to water. For example, you could be on land dealing with bridges or waterways. You could wind up being in a federal court. If two or more states are involved, it goes to a federal court, and that makes a lot of sense. If New York and New Jersey are about to have a disagreement, New York would want the trial in their state, New Jersey in their state, so we make it so that you go to a federal court. If the United States government is part of this suit, then it goes to a federal government. If citizens of different states are part, it also goes to a federal government. If you were suing somebody in Arizona, you would wind up in a federal court. And finally, if an ambassador or any American diplomat is involved, it goes to a federal court. So in the U.S., we have a two-tier system, basically, or a dual system. We have federal courts, which deal with federal crimes, and we have state courts that deal with state crimes. For our purposes today, we're going to focus just on the federal courts and take a look at the different types that are out there. So the structure of our system. There are two types of federal courts, and you can see we're going to start with the article courts. So, article courts. These are the courts that are created by Congress. They're in Article 1, Section 8, Clause 9, and it says that Congress can create, quote, lesser or inferior courts. So what are some examples of these? We have territorial courts for places like Guam, the U.S. Virgin Islands, and so on. These are places where we own them, but we have to allow some judicial powers to exist there, so we create special courts for them. We have a U.S. Court of Military Appeals, which was created because we recognize that the military is different than regular society, and that you have to have some balance there so that you can maintain discipline in the armed forces, but at the same point, make sure that people who are in the military and are accused of rights have some protections also. So we have these special courts that exist there. We have the U.S. Court of Veteran Affairs or Appeals. And this is if you are a veteran and you feel that something was not done properly, whether it be a survivor's benefit or disability benefits, or you could have received a loan and didn't get it, you can go to the U.S. Court of Veterans Appeals and file your case. We have another court, and this is a very big court. This is the U.S. Court of Federal Claims, previously called the Claims Court. And this one hears all kinds of things, and you can take a look at some of them. They hear things about tax refunds, federal taking of private property for public use. Hopefully you remember what that term is. What's that term? Yes, that's correct. Eminent domain. Very good. You might remember that's in the Fifth Amendment. They deal with constitutional and statutory rights of the military and their dependents, and you can read what these are. But this is a big court that hears a lot of cases and is also the court which is kind of a stepping stone to the Supreme Court. Many justices or judges who have been on the Federal Claims Court wind up becoming Supreme Court justices. So those are the biggies there. And you can see here, these judges get to follow enumerated powers of Congress. They do what Congress specifically says. There's a big difference between these judges and the judges who sit in district courts. These judges have a fixed term of office. It is 10 years. They do not have life tenure. Again, they do not have life tenure. So that's a very big difference from the Article 3 courts, which we're about to get to. And you saw we had different examples there. So, Article 3, Constitutional Courts. Article 3 of the Constitution allows the Supreme Court, created the Supreme Court, and also, once again, gave Congress the power to create lesser and inferior courts. It's mentioned twice in the Constitution. Now, these courts, if you are a judge in these courts, a district court, a court of appeal, or the Supreme Court, you have life tenure. That means once you have been nominated by the president and confirmed by the Senate, you will hold that position as a judge for the rest of your life or until you retire, resign, or die, or impeached and removed if that were to occur, which is very rare. Now, why would we give judges life tenure? We've gone over this a couple of times at this point, but you have to keep in mind that judges, because of the life tenure, do not have to fear the wrath of voters. The best example that I can come up with, and we've used this one before, is the Supreme Court in the Brown versus the Board of Ed decision. The Supreme Court did not have to worry about what people in Topeka, Kansas, or any place really thought of their decision that segregation was inherently unfair, that you separate but equal was inherently unfair. They were able to do something that elected officials were unwilling to do because it was not popular with the people at the time. So when we created our Constitution and we decided that judges and justices are those who are on the Supreme Court, should have life tenure, we wanted them to be able to do things because it was in the Constitution. It was the interpretation of the Constitution, not because they thought the people might or might not agree with them. The idea of giving judges this freedom was so that they could do things that should be done where the people might not be ready for them to happen. So, what are these courts? We start with our district courts. Almost all federal cases start in district courts. You can see there are a couple of others. The United States Court of International Trade, Federal Claims, Tax Court handle the ones that aren't in district courts. These district courts, there are 94 of them. They have a total of 665 judges. Our closest federal district court is downtown San Diego. If you get called for jury duty, you could wind up on state jury duty, which is downtown also, or federal jury duty. They're in opposite buildings. To give you an example of the number of cases these courts hear, it's really a lot. In 2013, district courts heard 284,604 civil cases. Those are cases where individuals are suing each other. There's not a violation of criminal law, but there is a wrongdoing somewhere and a lawsuit has been filed. And they also heard another 91,266 criminal cases. Cases like kidnapping, tax evasion, tampering with the mail. Those would be federal crimes. In these cases, there is a judge and a jury. There is a grand jury which issues indictments, and grand juries have been in the news recently. The grand jury protection is in the Fifth Amendment also, and it is a group of people who determine whether or not there is a possibility that you may have been involved in a crime. If there is a possibility that you committed the crime, then they will issue an indictment, and when you go on trial, a jury will determine whether or not you violated the law beyond a reasonable doubt if it is a criminal case. They use magistrates, which is a type of judge who can issue warrants, hold preliminary hearings, set bail. Basically, they do the pre-work. Their jurisdiction is original. This is a trial court. That you can have a civil case, a criminal case, or a constitutional case heard by these district courts. If you feel that your rights have been violated, you can file an appeal. Now, once you file an appeal, there is no guarantee it's going to be heard. An appeal simply means that you feel something was not right. It's up to an appeals court to determine whether or not to take your case. For example, let's say that you are on trial, and you're on trial for murder, and you're not a wealthy person, so you have an attorney who's been appointed by the court to defend you. And during your murder trial, the attorney falls asleep several times during the trial. Would you be able to make an argument that that constituted an unfair trial? If you made that argument after you were convicted, you could file an appeal to a court of appeals, and it's up to them to say, you know, that might have had an impact on the trial. We'll take that case. Or they could say, you know, it depends when the person fell asleep, if it was an important time in the trial or not. That's entirely up to the Court of Appeals. One of the problems that we do see with our district courts is there are a lot of vacancies. Some of this deals with the partisanship that is prevalent throughout Washington and in the Senate. Some of it just deals with people who feel like they can make a lot more money in the private sector than as a judge. Yes, you have lifetime tenure, but you're going to make about $180,000, $190,000 a year. If you're a top-notch lawyer, you could make significantly more than that. So that has been a problem. Now, we get down to the Court of Appeals, and I want to show you the map. This is what the Court of Appeals map looks like, and you can see that they are numbered, going with 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, and 11. You will notice 9 is huge. That is ours. We are in the Ninth Circuit Court of Appeals. It is by far the largest in both population and I believe geography. Definitely geography, never mind, in the United States. So what does that mean? Any case that is tried in a district court in any of these areas, if there is an appeal, that appeal is filed to the Ninth Circuit Court of Appeals, and it is up to them to determine whether or not to accept it. Now, an interesting piece here. So let's say, and I'll use one that's been in the news a lot. Let's say there's an appeal over whether or not to allow same-sex marriage. It comes to the Ninth Circuit, and the Ninth Circuit Court of Appeals says, yes, same-sex marriage should be allowed. Well, if they say that, that only applies to the Ninth Circuit Court of Appeals area. So now we go to, let's say, the Fifth Circuit. The Fifth Circuit might say, no, we don't think that under our Constitution there should be same-sex marriage. If you have two Circuit Court of Appeals who have a different judgment, a different decision, then that case is very likely to go on to the Supreme Court. That's how you wind up many times with the Supreme Court. So, just finishing this up, you can see the Court of Appeals, and yeah, there are 13. 1 to 11 are regionally spread out across the U.S. The 12th is for D.C., and the 13th is the Court of Appeals for the Federal Circuit. That's the one that I showed you a little bit earlier. These judges are busy. In 2013, 179 judges heard 56,475 cases. When they hear a case, it is not a single judge. It is usually a panel of 3 judges, except in a case where they are asked to hear a case what's called en banc. En banc means that all the judges from that Circuit Court of Appeals will hear a case. It is very rare, but it has happened. Their jurisdiction is appellate, which means they cannot be the first court to hear something. There's going to be a district court that has heard it, and it will be appealed to them. They will hear appeals, as you can see, from the district courts and also from regulatory commissions. If someone feels that there was a violation through like the EPA, an appeal could go to here. There's only one stop after this. It is the last one, and that will be the Supreme Court of the United States. Basically, after the Court of Appeals, and just to go back really quickly to show you, after the Court of Appeals, where they heard 56,475 cases, you have one last appeal. That appeal is going to be the U.S. Supreme Court, and the U.S. Supreme Court is going to take, on average, about 80 to 90 cases a year. So, once the Court of Appeals makes a ruling, it's pretty much done. And yes, that was my phone that went off a moment ago. So, that brings this lecture to an end, and I will see you all tomorrow.